The demand that India's political destiny should be determined by the Indians themselves had been put forward by Mahatma Gandhi as early as in 1922. The idea of a constitutional assembly for India was put forward for the first time by M.N. Roy in 1934. The demand for constitutional assembly was first accepted by the British in August offer of 1940, but the constitutional assembly was set up in November 1946 as per the Cabinet Mission Plan of 1946. The first meeting was held on 9th December 1946 with Sachindran Sinha as its interim president. On 11th December 1946, Dr. Rajendra Prasad was elected as the permanent president of the Constituent Assembly. It took almost 3 years, that is, 2 years, 11 months, and 18 days, to complete its historic task of drafting the Constitution for independent India. On 29th August 1947, the Constituent Assembly set up a drafting committee under the chairmanship of Dr. B.R. Ambedkar to prepare a draft constitution for India. Enactment and enforcement of the Constitution. The Constitution of India was adopted on 26 November 1949 and the honorable members appended their signature to it on that day. In all, 284 members actually signed the Constitution. 26 November 1949 is also mentioned in the preamble as the date on which the people of India adopted, enacted, and gave to themselves the Constitution. The Constitution came into force on 26 January 1950, was specifically chosen as the date of commencement of the Constitution because this day in 1930, the Purna Swaraj Day was celebrated. Constitution committees and their chairmen are as follows. Drafting Committee Chairman Dr. B.R. Ambedkar, Union Power Committee Chairman Jawaharlal Nehru, Union Constitution Committee Jawaharlal Nehru, Provincial Constitution Committee Sardar Patel, Advisory Committee on Fundamental Rights and Minorities Tribal Affairs Sardar Patel, Rules of Procedure Committee Dr. Rajendra Prasad, States Committee Jawaharlal Nehru, Steering Committee Dr. Rajendra Prasad, Special Committee to examine the draft constitution Sir Alladi Krishna Swami Iyer. These are the borrowed features of our Indian Constitution. The following were adopted from UK, England, that is parliamentary system, lower house more powerful, prime minister, cabinet system of ministers, single citizenship, bicameral parliament, provision of speaker in Lok Sabha, council of ministers responsible to lower house, nominal head the president. From USA, written constitution, post of vice president, fundamental rights, Supreme Court, head of the state known as president, provision of states, and judicial review. From France, republic and ideals of liberty, equality, and fraternity. From Australia, concurrent list, state center relationship, joint sitting of the two houses of the parliament. From USSR, fundamental duties and ideals of justice, that is, social, economic, and political, in the preamble. From Germany, suspension of fundamental rights during emergency. From Japan, procedure established by law. From Canada, federal system and residuary power with strong center and advisory jurisdiction of Supreme Court. From South Africa, procedure of constitutional amendment and election of member of Rajya Sabha. From Ireland, concept of directive principles of state policy. Originally it was brought from Spain. Mode of election of president and nomination of members to Rajya Sabha. Characteristics of Indian Constitution. These are the salient features of Indian Constitution. The lengthiest constitution in the world, universal adult franchise, blend of rigidity and flexibility, parliamentary government, independent judiciary, federal system with unitary features, secular state, single citizenship, single constitution, division of power between center and states, emergency provisions, single judiciary, power of parliament to amend constitution, independent bodies like comptroller and auditor general, election commission, etc. Difference between unitary and federal constitution. Unitary constitution has single citizenship, federal constitution has dual citizenship, single constitution, dual constitution, power of union to override on the state matters, division of power between center and states, change in the names and boundaries of the state by the parliament, changing the names and the boundaries of the states by the Conference of the States, integrated judiciary, dual judiciary, no units have rights to succeed from center, units have the right to separate from center, dependence of state on the center for economic assistance and grants, residual power given to states. Britain has unitary constitution. US constitution is a federal constitution. The preamble and its significance. The objective resolution moved in the Constituent Assembly by Nehru on 13 December 1946 was adopted by the Assembly on 22 January 1947 and later became the preamble of the Constitution. Preamble is an integral part of the Constitution. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote all of them, fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves the Constitution. So far, preamble has been amended only once in 1976 by the 42nd Amendment, which inserted the word socialist and secular, separation of religion from the state, and integrity. Schedules in the Constitution. First schedule, list of state and union territories. Second schedule, salary of president, governors, chief justice, judges of High Court and Supreme Court, comptroller and auditor general. Third schedule, forms of oath and affirmations. Fourth schedule, allocate seats for each state of India in Rajya Sabha. Fifth schedule, administration and control of scheduled areas and tribes. Sixth schedule, provisions for administration of tribal areas in Assam, Meghalaya, Tripura, Mizoram. Seventh schedule gives allocation of powers and functions between unions and states. It contains three lists: union list for central government 100 subjects, state list for power of state government 61 subjects, and concurrent list both the union and states has 52 subjects. Eighth schedule, list of 22 languages of India recognized by constitution. Ninth schedule, added by the first amendment in 1951, contains acts and orders related to land tenure, land tax, railways, and industries. 10th schedule, added by 52nd Amendment in 1985, contains provisions of disqualification on grounds of defection, that is anti-defection law. 11th schedule by 73rd Amendment in 1992 contains provisions of Panchayati Raj. 12th schedule by 74th Amendment in 1992 contains provisions on municipal corporation. Parts of the Constitution. There are 25 parts in our Constitution which are described as below. Part 1 from Articles 1 to 4 deals with territory of India, formation of new states, alterations of names and areas of existing states. Part 2, Article 5 to 11 deals with various provisions related to citizenship. Part 3, Article 12 to 25 deals with fundamental rights of Indian citizens. Part 4, Article 36 to 51 deals with directive principles of state policy. Part 4A deals Article 51A, added by 42nd Amendment in 1976, contains the fundamental duties of the citizens. Part 5, Article 52 to 151 deals with government at the union level, duties and functions of the Prime Minister, President, Vice President, Minister, Attorney General, Parliament, Lok Sabha and Rajya Sabha, Comptroller and Auditor General. Part 6, Article 152 to 237 deals with government of state level. Article 152 except Jammu and Kashmir from the category of ordinary states. Duties and functions of Chief Minister and his Minister, Governor, State Legislature, High Court, Advocate General of the state. Part 7, Article 238 deals with states in Part B was repealed in 1956 by the 7th Amendment. Part 8, Article 239 to 241 deals with union territories. This will also deal with Jammu and Kashmir now. Part 8, Article 239 241. Part 9, Article 243 to 2, Article 243 to and Part 9A, Articles 243P, 43ZG. Part 9 was added by 73rd Amendment in 1992, contains a new schedule, Schedule 11. It contains 29 subjects related to Panchayati Raj. Part 9A was added by 74th Amendment in 1992. Contains a new schedule, Schedule 12. It contains 18 subjects related to municipalities. Part 9B deals with cooperative societies. Part 10, Article 244 and 244A deals with scheduled and tribal areas. Part 11, 245 to 263 deals with relation between union and states. Part 12, 264 to 300A deals with distribution of revenue between union and states, appointment of finance commission. Article 280, contracts, liabilities, etc. Part 12, Article 301 to 307 relates to trade, commerce, and intercourse within the territory of India. Part 14, Article 308 to 323 deals with Civil Services and Public Service Commission. Part 14A, Article 323A, 323B deals with tribunals. Part 15, 324 to 329A deals with elections, including Election Commission. Part 16, 330 to 342 deals with special provisions for scheduled castes and scheduled tribes and Anglo-Indian representation. Part 17, 343 to 351 relates to official language. Part 18, 352 to 360 deals with emergency provisions. Part 19, 361 to 367 miscellaneous provisions. Part 20, 368 deals with amendment of constitution. Part 21, 369 to 392 contains temporary, transitional and special provisions. Part 22, 393 to 395 concerns the short title Commencement authoritative text in Hindi and repeals of the Constitution. National symbols. National flag. It was designed by Pingali Venkaya of Andhra Pradesh on 22nd July 1947. It was adopted by Constituent Assembly. It follows 3:2 between length and breadth. It has three colors: saffron, white, and green. Middle portion has Ashoka Chakra in blue with 24 spokes. National emblem. It has been taken from Sarnath, Varanasi, Pillars of Ashoka, and on 26 January 1950 it was adopted by the Government of India. The word Satyamev Jayate, which was written at the base in Devanagari script taken from Mundak Upanishad, is the national motto of India. National anthem. It was written by Rabindranath Tagore. Its recitation period is 52 seconds. First time it was sung in Calcutta Congress session on 27th December 1911. On 24th January 1950, Constituent Assembly adopted it, Jana Gana Mana, as national anthem in India. National song Vande Mataram, taken from Bankim Chandra Chatterjee's work Anand Mat. It was officially adopted on 24 January 1950. It was sung for the first time at Kolkata session of Congress in 1896. National calendar, based on Saka era, Chaitra is its first month and a normal year of 365 days along with Gregorian calendar. It was adopted by the central government on 22nd March 1957. National animal, it is a tiger. It has 8 species around the world and Indian species is known as Royal Bengal tiger. The majestic Panthera tigris is the national animal of India. National bird, Indian peacock, Pavo Christians. It is fully protected under the Indian Wildlife Protection Act 1972. National tree, banyan tree. National aquatic animal, river dolphin. National river, Ganga. National fruit, mango. National flower, lotus. National heritage animal, Indian elephant. National reptile, king cobra. Important articles of the Constitution. The Indian Constitution is lengthiest in the world, comprising 465 articles in 2013, divided into 25 parts along with 12 schedules. The Union and its territories, Article 1 to 4. Article 1 deals with the name and territory of the Union. It describes India, that is the Bharat, as Union of States. The territory of India includes territories of state, union territories, and territories that may be acquired by the government of India at any time. Article 2 admission or establishment of new states. Article 3 formation of new states and alteration of areas, boundaries, or names of the existing states. Article 4 laws made under Article 2 and 3 for the amendment of the first and fourth schedule on supplement, incidental, and consequential matters. Reorganization of states. In 1956, there were 14 states and 6 union territories. Andhra Pradesh was created in 1953 and Kerala in 1956. In 1956, Karnataka was created. In 1960, Bombay was bifurcated into Gujarat and Maharashtra. In 1963, Nagaland was created as separate state. In 1966, Haryana was carved out of Punjab and Chandigarh became union territory. In 1970, the Union Territory of Himachal Pradesh was elevated to the status of state. In 1971, Manipur, Tripura, and Meghalaya were granted the statehood. In 1974, Sikkim became an associate state of the Indian Union by the 36th Constitutional Amendment Act 1975. Sikkim became a full-fledged state of the Indian Union. In 1986, Mizoram and Arunachal Pradesh came into being. In 1987, Goa came into existence. In 2000, three more states, Chhattisgarh, Uttarakhand, and Jharkhand, were created. On 2nd June 2014, Telangana state came into existence after reorganization of Andhra Pradesh. Articles 5 to 11 deals with citizenship. The Constitution of India provides for single citizenship. There is no separate citizenship of state. According to the Constitution, the following three categories of person are entitled to citizenship: person domiciled in India, refugees who migrated to India from Pakistan, Indians living in other countries. Article 5 citizenship of at the commencement of the Constitution. Article 6 rights of citizenship of certain people who have migrated to India from Pakistan. Article 7 rights of citizenship of certain migrants to Pakistan. Article 8 rights of citizenship of certain persons of Indian origin residing outside India. Article 9 persons voluntarily acquiring citizenship of a foreign state not to be citizens. Article 10 continuance of rights of citizenship. Article 11 Parliament to regulate the right of citizenship by law. Acquisition and termination of citizenship. Rules regarding acquisition and termination of Indian citizenship have been laid down in the Citizenship Act of 1955. This is now amended, but the basic frame structure is the same, and the certain terms are naturalization and other things have been re, uh, redone. Brand: B by birth, R by registration, A by acquisition of territory, N by naturalization, and D by descent. Termination of citizenship can be terminated in three ways. It can be voluntarily renounced by a citizen. It can be terminated if a person acquires citizenship of some other country. The central government can deprive a naturalized citizen if it is satisfied that a citizenship was acquired by fraud, false representation, or concealment of material facts, or if the person shows disloyalty towards the Indian Constitution, or indulges in the trade with enemy countries, or if the person has been sentenced to imprisonment for a period of 2 years or more within 5 years of his registration, or if he has been continuously residing out of India for more than 7 years. Article 11. Under this article, Parliament has the power to enact laws regarding citizenship. It has the power to regulate the right of citizenship in India. The Citizenship Amendment Act 2015. The Act seeks to amend the Citizenship 1955. The major provisions of the Act are as follows. In case of citizenship by naturalization, the Act allows the central government to relax the requirement of 12 months stay or in service of government. If special circumstances exist, relaxation up to 30 days may be permitted. The Act provides certain additional grounds for registering an overseas citizens of India card. The Act also introduces a new provision which allows the central government to register a person as an overseas citizen of India card holder even if he or she does not satisfy any of the listed qualifications if special case exists. The Act provides for merger of overseas citizens of India and persons of Indian origin scheme. Thus, the central government may notify that persons of Indian origin cardholders shall be considered to be overseas citizens of India cardholders from a specified dates. The Act also allows central government to cancel the overseas citizenship of India card where it is obtained by the spouse of an Indian citizen or overseas citizen of India card holder if marriage is dissolved by the court or the spouse enters into another marriage even while the first marriage has not been dissolved. Overseas citizen of India. Government of India recognizes those persons and provide them overseas citizen of India card who have following credentials are now citizen of India, citizen of another country, but was citizen of India at time of or at any time after commencement of constitution, who were citizen of other country but eligible to become citizen of India at time of commencement of constitution, who is citizen of another country but belong to a territory that became part of India, and child, grandchild, great grandchild of the above such citizens. Persons of Pakistan and Bangladesh can't get an overseas citizenship of India card. Recently, government has merged people of Indian origin card with overseas citizen card. Non-resident Indian. A citizen of India having Indian passport and staying temporarily in another country for purpose of employment, education for more than 6 months. Pravasi Bharatiya Divas. It is celebrated on 9th January every year to recognize contribution of overseas Indian community in development of India. 9 January is selected because on this date Mahatma Gandhi returned to India from South Africa. This celebration provides the opportunity to overseas citizens of India to interact with government and people of their homeland. Pravasi Bharatiya Divas PBD started from year 2003. The 14th Pravasi Bharatiya Divas was held on 9 January 2016 in New Delhi. The event was attended by Priti Patel. Fundamental rights. Fundamental rights and directive principles have common origin. Nehru Report to 1928, which incorporates some fundamental rights. The framers of Constitution derived inspiration from the Constitution of USA, that is, Bill of Rights. Part 3 of Constitution is rightly described as Magna Carta of India. Article 12. Definition of state, which includes the government and Parliament of India, the state government, legislative assemblies, and all local or other authorities within the territory of India as under the control of Government of India. Article 13. Laws inconsistent with or in derogation of the fundamental rights. Types of fundamental rights. These are six in number, which are rights to equality, Article 14 to 18. Article 14, equality before law and equal protection of law. Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 16, equality of opportunities in matter of public employment. Article 17, abolition of untouchability and prohibition of its practice. Article 18, abolition of titles except military and academic. Right to freedom, 19 to 22. Article 19, it guarantees the citizen of India six fundamental freedoms, which are as follows: freedom of speech and expression, freedom of press, media. Second, to assemble peacefully and without arms, to form association or unions, to move freely throughout the territory of India. Fifth, to reside and settle in any part of the territory of India. Sixth, freedom to choose any profession and business. Article 20. It gives protection in respect of conviction for offences. Article 21. It gives protection of life and personal liberty to both citizens and non-citizens. Article 20 and 21 remain in force even during emergency. Article 21A. Right to education from age 6 to 14 years, made a fundamental right by 86 Constitutional Amendment 2002. Article 22. It entails protection against arrest and detention in certain cases. This right is not available to an enemy alien and a person arrested or detained under a law providing preventive detention of a person without trial. Right against exploitation. Article 23 and 24. Article 23 entails prohibition of traffic in human beings and forced labor. Article 24 that no child below the age of 14 can be employed in factories or mines or in hazardous employment. Article 25 to 28 right to freedom of religion. Article 25 freedom of conscience and free profession, practice and propagation of religion. Article 26 freedom to manage religious affairs. Article 27 freedom from payment of taxes for promotion of any particular religion. Article 28 it prohibits any religious instruction in educational institution wholly maintained by state funds. In other institutions aided and recognized by the state, every person will be free not to participate in religious instruction or worship. Cultural and educational rights. Article 29 to 30. Article 29 allows every community to conserve its distinct language, script, or culture. It also bars disallowing a citizen admission to any educational institution maintained or aided by the state only on grounds of religion, race, caste, or language. Article 30 rights of minorities to establish and administer education institutions. Right to constitutional remedies. Article 32 it provides the right to the citizens to move to the Supreme Court by appropriate proceedings for the enforcement of the fundamental right, and it empowers the Supreme Court to issue directions or writs for the enforcement of the fundamental rights. The writs includes habeas corpus, mandamus, prohibition, quo warranto, certiorari. Dr. B.R. Ambedkar termed the right to constitutional remedies as the heart and soul of Constitution. Article 33 enables Parliament to modify fundamental rights in relation to military or paramilitary forces, police forces, or analogous forces. Empowers Parliament to make any law indemnifying any person for acts done during the operation of martial law. Article 35. This article provides for powers to make laws on certain articles. In this part, the Parliament and excludes only on the Parliament and excludes the state legislature jurisdiction from them. Right to property. Article 31. Right to property repealed by the 44th Amendment Act 1978. Now it is only a legal right. Right to information. Right to information has been granted to every citizen of India under RTI Act 2005, which came into force on 12th October 2005. It is not a fundamental right. It entails a clause for penalty in case of delay in giving information to the applicant. Information Commission has been set up at central and state levels to oversee the implementation of the act. Directive principles of state policy. Dr. B.R. Ambedkar described the directive principle of state policies as a novel feature of the Constitution. DPSPs are constitutional instructions or guidelines to state in the legislative, executive, and administrative affairs. It provides the social and economic base of a genuine democracy. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories: socialistic, Gandhian, and liberal. Article 38 to secure a social order which stands for the welfare of the people. Article 39 the state shall direct its policy towards securing equal access, to provide adequate means of livelihood, to prevent concentration in wealth and means of wealth and material resources, to secure equal pay for equal work for both men and women, to provide necessary opportunities and facilities to children and youth to prevent their exploitation. Article 41 to make efforts to secure the right to work, education, and public assistance in case of unemployment, sickness, old age, etc. Provision for just and humane condition of work and maternity relief. Article 43 to ensure a decent standard of living and social and cultural opportunities for all workers. Article 43A securing the participation of workers in the management of industries. Article 47 duty of the state to raise the level of nutrition and the standard of living and to improve public health. Gandhian principles. Article 40 the establishment of village panchayats and make them powerful enough to function as units of self government. Article 43 to promote cottage industries. Article 43b the promotion of cooperative societies. Article 46 the promotion of education and economic interest of the weaker sections. Article 47 the prohibition of intoxicating drugs and drinks. Article 48 prevention of the slaughter of cows and other milk cattle. Liberal principles. Article 44A a uniform civil code. Article 45 provision for free and compulsory education for children. Article 48 organization of agriculture and animal husbandry. Article 48A protection and improvement of environment and safeguarding of forests and wildlife. Article 49 protection of monuments and places and objects of national importance. Article 50 separation of judiciary from executive. Article 51 promotion of international peace and security. Difference between fundamental rights and directive principle of state policy. Fundamental rights. The democratic political system has been established by providing the fundamental rights. Directive principle of state policy. The economic welfare of the state is established by the implementation of the DPSPs. Fundamental rights are subject to court of law at any point of time if anybody feels that his fundamental rights are being violated, while DPSPs are not enforceable by the court of law. Fundamental rights can be suspended except the right mentioned in Article 20 and 22 during emergency. DPSP can never be suspended under any condition. Fundamental rights are assumed negatively sometimes because they are restrictive attitudes towards the states. DPSPs are always affirmative because they direct the states for definite activity. Fundamental rights are a bit limited in scope, while the scope of directive principles of state policy is endless. The political, administrative, and economic and subjects like international peace are also included. Fundamental duties, Article 51A. The fundamental duties in the Constitution serve as a reminder to the citizens that while enjoying their rights, they should also be conscious of their duties towards the country. They were added by the 42nd Amendment Act 1976. It contains the duties of the citizens. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideas which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment including forests, lake, river and wildlife, to have compassion for living creatures, to develop the scientific temper, humanism and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. For every citizen who is a parent or guardian, to provide opportunities for education to his child, or as the case may be, the ward between the age 6 to 14 years. The 11th fundamental duty was added by 86th Constitution Amendment in 2002. The Union. It deals with the Union government. It contains the duties and functions of Prime Minister, Minister, President, both the houses, Attorney General, Comptroller and Auditor General, President. Article 52 to 78. Article 52 provides for the office of President of India. The President of India is the highest executive authority. The Constitution vests in him all the executive powers of the Union. All executive actions are taken on his name. He is the head of the state and represents the Republic of India and is the first citizen of India. Election. Article 54, 55, and 71. The President of India is not directly elected by the people but by the members of the Electoral College consisting of elected members of both the houses of parliament, the elected members of Legislative Assembly of the state, the elected members of Legislative Assembly of Delhi and Puducherry. Nominated members do not take part in the election of the President. Election is held through the system of proportional representation by means of the single transferable vote by secret ballot. The candidate who gets minimum 50% votes is considered elected. States have different representation in presidential election depending on the population and the number of elected members of legislative assembly. Value of vote of an MLA is equals to state population divided by total number of elected MLAs into 1000. Value of vote of a member of parliament is equals to total value of MLAs of all states divided by total number of elected member of parliaments, that is Lok Sabha and Rajya Sabha. This formula secures the uniformity between all the states on one hand and parliament on the other. Security deposit is 15,000 only. Only Supreme Court inquires all dispute regarding presidential election. President takes oath in presence of Chief Justice of India and in his absence the senior-most judge of Supreme Court administers oath to the president. President who died on their posts are Zakir Hussain and Fakhruddin Ali Ahmad. Only president elected unopposed is Neelam Sanjeeva Reddy. President who served as Speaker of Lok Sabha before becoming president is Neelam Sanjeeva Reddy. Only Chief Justice who acted as President of India is Justice Hidayatullah. Only president who was elected twice is Dr. Rajendra Prasad. Term of office and emolument. Tenure is 5 years, Article 56. Article 57, there is no limit as to how many times a person can become president. He can give his resignation to the vice president before the full term completes. The president may be removed from office before the expiry of his tenure through a special procedure called impeachment. Qualification. Article 58 deals with the qualification of a person to the President of India. He must be a citizen of India, should have completed the age of 35 years, should not hold any office of profit under the government. He should be qualified to become the member of Lok Sabha. Impeachment. Article 61, the President can be impeached only on the grounds of violation of Constitution. The process may start from any house of the Parliament. The charges are contained in notice which has to be signed by at least one-fourth of the total member of that house. 14 days notice is sent to the President. A resolution to impeach the President has to be passed by a two-third majority of the total member of that house. It is then sent to the other house, which investigates this charge. The President has the right to defend himself through an authorized counsel. If the second house also approves the charges by a two-third majority, the President removed from the office. Vacancy. Article 62. In case of vacant seat due to any reason, that is death, resignation, removal, the Vice President acts as the President. If he is not available, then Chief Justice of India. If not, then senior most judge of the Supreme Court. The election is to be held within 6 months of the vacancy. Powers and functions. Article 77. The President has a very important role. He has vast powers to be exercised during normal time as well as in emergency period. These powers, however, are actually exercised by the Prime Minister and the Council of Ministers. Executive powers of the President. He appoints Prime Minister who enjoys the support of the majority as the Lok Sabha. In the Lok Sabha, appoints the members for the Council of Ministers and distributes portfolios among them on the advice of the Prime Minister. He appoints Chief Justice and judges of Supreme Court and High Court, Chairman, members of the UPSC, CAG, Attorney General, Chief Election Commissioner and other members of Election Commission, governors, members of Finance Commission, ambassadors, etc. He can seek any information relating to the administration of affairs of the Union and proposal for legislature from the Prime Minister. Legislative powers. The President of India is an integral part of the Parliament. Though legislation is the primary responsibility of the Parliament, the President has the right to influence the legislative process in the following ways: the resolution and the propagation of the Parliament, right of President to address and send messages to both the houses, nomination of members of Parliament, 12 members to Rajya Sabha and 2 members from Anglo-Indian community in Lok Sabha, laying down some reports at the floor of the Parliament, prior consent on some bills, example, money bill. Any bill becomes law only after assent of the President. Ordinance making power of President. Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of Parliament. These ordinances have the same force as Act of Parliament but are in nature of temporary laws. Veto power. President has three veto powers: absolute veto, suspensive veto, and pocket veto. President can also veto bills of state legislature which are sent for his approval. President cannot return the money bill and constitutional amendments cannot be vetoed. Financial powers. All money bills can originate in Parliament only on the recommendation of the President. Appointment of Finance Commissioner every fifth year. Diplomatic powers. All kind of international treaties and agreements concluded on his behalf. He represents country on the international forum. He sends ambassadors and receives diplomats. Military powers. He is a supreme commander of armed forces. He appoints the chief of army, navy, and air force staff. He declares wars and concludes peace. Emergency powers. National Emergency Article 352, President's Rule Article 356 and 365, Financial Emergency 360, 352, 356 and 360. Judicial powers Article 77, President can grant pardon or reduce the sentence of any convicted person. Various pardoning powers of the President Article 72. Pardon, it removes the both the sentences and the conviction and completely absolves the offender from all punishments and disqualification. Reprieve. It means a stay of execution of sentence pending a processing or for pardon or commutation. Remission. The power of remission reduces the amount of sentence without changing its character. Example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment for 1 year. Respite. The power to grant respite means awarding a lesser sentence instead of the prescribed penalty in view of some special facts. Example, pregnancy of woman offender. Commutation. It merely substitutes one form of the punishment for another of a lighter character. Example, death sentence may be commutated by rigorous imprisonment. Presidents of India. First President Dr. Rajendra Prasad, 1950 to 1962. Dr. S. Radhakrishnan, 62 to 67. Zakir Hussain, 67 to 69. W. Giri, 69 to 69. Justice Hidayatullah, 69 to 69. V. Giri, 69 to 74. F. Ali Ahmad, 74 to 77. B. D. Jatti, 77 to 77. N. Sanjeev Reddy, 77 to 82. Gilani Zail Singh, 82 to 87. R. Venkataraman, 87 to 92. S. D. Sharma, 92 to 97. K. R. Narayan, 97 to 2002. Abdul Kalam, 2002 to 2007. Pratibha Patil, 2007 to 2012. Pranab Mukherjee, 2012 to 2017. Ramnath Kovind, 2017 to present. As per Article 63, there shall be a Vice President of India. He occupies the second highest office in the country. In absence or illness of the President, the Vice President performs the function of the President. If the President resigns or dies, the Vice President officiates as a President till a new President is elected. The Vice President is elected by an electoral college constituted by the members of of the both houses of the Parliament in accordance with the system of proportional representation by means of single transferable vote and the vote being secret. Nominated members also participate in the election. Supreme Court inquires all disputes regarding Vice President election. Qualification. He must be a citizen of India and should have completed the age of 35 years. Eligibility to become a member of Rajya Sabha. Note. Must not hold any government post. Terms and function. He is elected for 5 years and can be re-elected. He is the ex officio chairman of the Rajya Sabha. All bills, resolution, motion can be taken in Rajya Sabha after his consent only. Emoluments. The Vice President derives his salary as the ex officio chairman of the Rajya Sabha, which is currently 1.25 lakh per month. During the period he acts as the President, he receives the salary and allowances of that of President. Removal. The Vice President can be removed from his office by a resolution of the Rajya Sabha passed by a majority of all the then members of Rajya Sabha and agreed to by House of People, Lok Sabha. Regarding Vice President, there is no formal impeachment. The Vice President may also resign from his office by writing to the President. These are the Vice Presidents of India: Dr. Sarvapalli Radhakrishnan, 52 to 62; Zakir Hussain, 62 to 67; V.V. Giri, 67 to 69; Gopal Swarup Pathak, 69 to 74; B.D. Jatti, 74 to 79; Justice Hidayatullah, 79 to 84; Venkataraman, 84 to 87; Shankar Dayal Sharma, 87 to 92; K.R. Narayan, 92 to 97; Kishan Kant, 97 to 2002; Bhairav Singh Shekhawat, 2002 to 2007; Muhammad Hamid Ansari, 2007 to 2017; Venkaiah Naidu, from 2017 till present. Council of Ministers. Council of Ministers is formed as soon as Prime Minister is sworn in. Only a Prime Minister alone can constitute Council of Ministers after 91st Amendment Act 2003. Article 75 1A states that strength of Union Council of Ministers shall not increase 15% of the total strength of the Lok Sabha. The Council of Ministers consists three categories of minister, namely Cabinet Minister, Minister of State, and Deputy Minister. Cabinet Ministers. They are in charge of important portfolios. They are the real policy makers. The cabinet meetings are not attended by other ministers. Okay. Ministers of State, one who holds independent charge of some ministries or are placed under a cabinet minister. Deputy Ministers, one who assists cabinet ministers and ministers of states. Council of Ministers shall be collectively responsible to the House of People. A person can remain a minister without being a member of either houses maximum up to 6 months. Prime Minister. The Prime Minister is the head of the central government. All the executive powers of the central government are formally vested with the President of India, but these powers are actually exercised by the Council of Ministers under the leadership of Prime Minister. The Prime Minister is appointed by the President. Prime Minister allocates portfolios among the ministers and he also can drop any minister. The Prime Minister presides over the meetings of the Council of Ministers. He decides about the policies of the government and coordinates the work of different ministers. The Prime Minister is the ex officio chairperson of the Niti Aayog and earlier was a chairperson of the Planning Commission. The Prime Minister, who is not a member of Parliament, has to acquire its membership within 6 months of his appointment. Prime Minister remains in power so long as he enjoys the majority in the Lok Sabha. If the Lok Sabha has no confidence, then the entire Council of Ministers has to be terminated. Collective responsibility. He advises the President about the presidential rule in the state or emergency in the country. The resignation of the Prime Minister means resignation of the entire Council of Ministers. Even a Rajya Sabha member can become a Prime Minister. Prime Ministers of India. Jawaharlal Nehru, 47 to 64; Guljari Lal Nand, 64 to 64; Lal Bahadur Shastri, 64 to 66; Guljari Lal Nand, 66 to 66; Indira Gandhi, 66 to 77; Morarji Desai, 77 to 79; Charan Singh, 79 to 80; Indira Gandhi, 80 to 84; Rajiv Gandhi, 84 to 89; Vishwanath Pratap, 89 to 90; Chandra Shekhar, 90 to 91; P.V. Narasimha Rao, 91 to 96; Atal Bihari Vajpayee, 96 to 96; H.D. Devanand Goda, 96 to 97; I.K. Gujral, 97 to 98; Atal Bihari Vajpayee, 98 to 99; Atal Bihari Vajpayee, 99 to 2004; Manmohan Singh, 2004 to 2014; Narendra Modi, 2014 till date. Powers and functions. In relation to the Council of Ministers, if a difference in opinion arises between the Prime Minister and any of his subordinate ministers, he can ask the minister to resign or can advise President to dismiss him. In relation of President, regarding the appointment of important officials like Attorney General of India, Comptroller and Auditor General, Chairman of UPSC, Election Commissioner, chairman of finance commission, etc. And the PM can advise the president. He advises the president with regard to summoning and proroguing of the sessions of the parliament. He can recommend dissolution of the Lok Sabha to to president at any time. Parliament. According to Article 79, the parliament consists of the president, the Council of States, Rajya Sabha, and the House of the People, Lok Sabha. Though the president is not a member of the either house, but he is an integral part of it. Rajya Sabha. Maximum strength 250. Out of these, President nominates 12 members amongst persons having special knowledge or practical experience in the field of literature, science, art, and social service. Presently, the Parliament by law has provided for 233 seats for the states and union territories. The total membership of the Rajya Sabha is 245. All the states and only two union territories, Delhi and Puducherry, are represented in the Rajya Sabha. Representatives of the Rajya Sabha are elected by the members of state legislative assemblies on the basis of proportional representation through a single transferable vote. States are represented on the basis of their population. There are no seats reserved for scheduled castes and scheduled tribes in Rajya Sabha. Conditions to be a member of Rajya Sabha are as follows: citizen of India, 30 years of age, be a parliamentary elector in state in which he is seeking election. Others as prescribed by Parliament from time to time. For 6 years, as one third member retire every 2 years. Vice President is the ex officio chairman of the Rajya Sabha. He presides over the proceedings of the Rajya Sabha as long as he does not act as the President of India during a vacancy in the office of the President of India. Also, a deputy chairman is elected from among its members. In Rajya Sabha, any bill can originate apart from money bill, including budget. Rajya Sabha is a permanent body and is not subject to dissolution like Lok Sabha. Special parts of Rajya Sabha. A resolution seeking any removal of the vice president can originate only in Rajya Sabha. If the Rajya Sabha passes a resolution by a majority of less than two-thirds of the members present and voting that it is necessary in the national interest that Parliament should make laws with respect to any matter enumerated in the state list, it shall be lawful for the Parliament to make law for a period of not more than 1 year. Article 249. If the Rajya Sabha passes a resolution by a majority of not less than two-thirds of the members present and voting, then it is necessary in the national interest to create one or more all India services. Parliament by law provide for such services or service. Lok Sabha. Maximum strength 550 plus 2, 530 for states and 20 for UTs. Present strength of Lok Sabha is 543 plus 2. Lok Sabha is not a permanent body and is subject to dissolution. The normal tenure of Lok Sabha is 5 years, but it may be dissolved earlier by the President. The life of the Lok Sabha can be extended by the Parliament beyond the 5 years term when a proclamation of emergency under Article 352 is in force. But the Parliament cannot extend the normal life of Lok Sabha for more than 1 year at a time. But in any case, such an extension cannot continue beyond the period of 6 months after the proclamation of emergency comes to an end. Quorum for either house. Article 100C. 1/10 of the total house of the total number of members. Conditions of Conditions to be a member of Lok Sabha: citizen of India and at least 25 years of age, must not hold any office of profit. He must not unsound he must be not of unsound mind or insolvent. He must be registered voter in any parliamentary constituency. A member can be disqualified if he voluntarily gives up membership of the party, if he overrules the whip, if he remains the if he remains absent for 60 days without intimation. A speaker. Presiding officer in Lok Sabha is the speaker. In his or her absent, the deputy speaker. The members among themselves elect him or her. The Speaker continues in office even after the dissolution of the Lok Sabha till a newly elected Lok Sabha meets. Speaker sends his resignation to Deputy Speaker. Usually, the Speaker, after his election, cuts off all the connections with his party and acts in an impartial manner. He does not vote in the first instance but exercises his casting vote only to remove a deadlock. charges his salary from the Consolidated Fund of India. The majority of the total membership can remove speaker after giving a 14 days notice. During this time he does not preside over the meetings. After his removal continues in office till his successor takes charge. Powers and functions of speaker. The speaker presides at the meetings of the House of the People as well as joint sitting of the two houses of the Parliament. The Speaker gives permission to the members of the members to speak in the House. If the quorum presence of only one tenth of the total strength in the House is not complete, the Speaker can adjourn the House. He decides as to whether bill is a money bill or not, and his or her decision is final. He appoints the chairman as well as deputy chairman of all the committees of the House. Speaker takes the final decision as to disqualifying a member on the grounds of defection. Pro tem speaker. The president appoints the senior most member of the newly elected Lok Sabha as the pro tem speaker. He has all the powers of the speaker, but he presides over the first sitting of the newly elected Lok Sabha and administers oaths to the new members. When the new speaker is elected by the House, the office of the pro tem speaker ceases to exist. Deputy Speaker. The Deputy Speaker of the Lok Sabha is the vice presiding officer of the Lok Sabha, the lower house of Parliament of India. He acts as the presiding officer in case of leave or absence caused by death or illness of the Speaker of the Lok Sabha. He holds office till either he ceases to be a member of the Lok Sabha or he himself resigns from the Lok Sabha. He can be removed from office by a resolution passed in the Lok Sabha by a majority of its members. He is supposed to resign from his original party because as a deputy speaker he has to remain impartial. Special powers of Lok Sabha. Money and financial bills originate only in Lok Sabha. The confidence has and no confidence motions can be introduced in Lok Sabha only. Article 352 says that Lok Sabha is a special sitting in a special sitting can disapprove the continuance of national emergency even when the Rajya Sabha rejects such a resolution. Allocations of seats in the parliament. Andhra Pradesh 25, Assam 14, Jharkhand 14, Gujarat 26, Himachal Pradesh 4, Karnataka 28, Madhya Pradesh 29, Maharashtra 48, Meghalaya 2, Nagaland 1, Punjab 13, Sikkim 1, Tripura 2, Uttar Pradesh 80, West Bengal 42, Chandigarh 1, Daman and Diu 1, Lakshadweep 1, Arunachal Pradesh 2, Bihar 40, Goa 2, Haryana 10, Jammu and Kashmir 6. This has changed now. Look up at the internet. Kerala 20, Chhattisgarh 11, Manipur 2, Mizoram 1, Odisha 21, Rajasthan 25, Tamil Nadu 39, Telangana 17, Uttarakhand 5, Andaman and Nicobar Islands 1, Dadra and Nagar Haveli 1, Delhi 7, Puducherry 1. Sessions of Parliament begins with the consent of the President. Gap between the two sessions should not be more than 6 months. The Parliament generally meets in a three sessions in a year, which are as follows: Budget session February to May. Sorry, it is the longest session, February to May. Monsoon session, July to August. Winter session, November December. It is the shortest session. Joint session. It is ordered by the President to consider a particular bill in case bill passed by one house and rejected by other, with the amendments made by the other house are not acceptable to the house where the bill is originated. When a bill remains pending or unpassed for more than 6 months. Joint session of Parliament is presided over by the Speaker of the Lok Sabha. In his absence, the Deputy Speaker, or in his absence, the Deputy Chairman of the Rajya Sabha, or in his absence, any member of the Parliament who is acceptable to the both houses. Deadlock over the bill is resolved by a majority of the members of both houses of the Parliament present and voting. The Lok Sabha has larger membership. No fresh amendments can be done in joint session. There is no provision of joint session for passing money bills and constitutional amendments. In Indian history, only three bills have been referred to joint sitting: Dowry Prohibition Bill 1961, Banking Service Commission Bill 1978, Pota Bill 2002. Termination of sitting. The sitting of the House may be terminated by dissolution. The Lok Sabha is subjected to dissolution. Resolution takes place when President exercises his power under Article 85 to it can be dissolved on the expiry of its term of 5 years. Prorogation. It means the termination of a session of the House by an order made by the President under Article 82 2A of the Constitution. Adjournment. It does not put an end to the existence of the session of a parliament, but it merely postpones the further transaction of business for a specified time, hours, days, or weeks. Adjournment generally does not have any effect on the pending business. Question hour. The first hour of sitting of Lok Sabha devoted to questions and that hours is called question hour. The question hour of three kinds: starred, unstarred, and short notice. 0 hour. The period follows the question hours and it starts at noon and the duration is 1 hour from 12 noon to 1 pm. During the 0 hour, various issues of public importance are raised without prior notice. Conduct of law in Parliament. The proposal for a law is called bill. Until a bill is passed through a proper procedure, it cannot be a law or an act. Only Speaker of Law, only Speaker of Lok Sabha decides whether the bill is a money bill or ordinary bill. Ordinary bill. All the bills other than financial bills, money bills, and the constitutional amendments are ordinary bills. An ordinary bill can be introduced in any of the two houses of Parliament and also introduced by either a minister of the government or any member of the House. Money bill. Money bill cannot be introduced without the consent of the President of India. Article 110. It can be introduced only in Lok Sabha. The Speaker certifies a bill to be a money bill and his decision is final in this regard. Article 110. Money bill relates to bills seeking imposition or abolition of taxes, matters pertaining to or borrowing of money by the government, custody and maintenance of consolidated funds, etc. When the money bill is passed by the Lok Sabha, it is sent to the Rajya Sabha for its recommendations. Rajya Sabha can delay it only for 14 days. Its final approval lies with the Lok Sabha only. Financial bill. Any bill dealing with revenues or expenditure but not certified as money bill by the Speaker is a financial bill. Financial bill can be introduced only on the recommendation of the President. Constitutional amendment bills. Under Article 368, with the power of the Parliament to amend the Constitution, this bill can be introduced in any of the two houses without recommendation of the President. Parliamentary committees. Committees have been created so that the members of Parliament can discuss and debate on the working of certain department of the government. Most of the committees function under the direction of the Speaker and essentially of the Lok Sabha. Members of the Rajya Sabha are associated with all the committees except Estimates Committee. The chairman of all the committees except for Joint Commission on Salaries and Allowances of MPs are appointed by the Speaker from amongst the members of the committees. In case a Speaker is a member of a committee, he becomes an ex officio chairman of the committee. Committees are classified under two heads: Standing Committee and Ad hoc Committee. Ad hoc committees are created for a temporary period. Standing committees are broadly classified into the following categories. The standing committee are broadly classified into the following two categories, or in the following categories: committee of inquiries, committees to scrutinize, financial committees, committees of administrative character, committees with provision of facility to member. Financial committees of Parliament are Estimates Committee, Public Accounts Committees, Committee on Public Undertaking, and 24 departmental related committees. The Public Accounts Committee was set up first in 1921 under the provision of Government of India Act of 1919. At present, it consists of 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. Since 1967, a convention has developed whereby the chairman of the committee is selected invariably from the opposition. The origin of Estimates Committee can be traced to the Standing Financial Committee set up in 1921. The first Estimates Committee was set up in 1950. It has 30 members from the Lok Sabha only. The Committee on Public Undertaking was created in 1964 on the recommendations of the Krishna Menon Committee. It has 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. In 1983, 17 departments related to standing committees were set up. In 2004, 7 more committees were set up. Thus, the total 24 committees set exist as of today. The accounts of government. Consolidated Fund of India. Article 266(1). All revenues received by the government by the way of taxes like income tax, central excise, customs, and other receipts flowing to the government in connection with the conduct of government business, that is, non-tax revenues, are credited into the consolidated funds constituted under Article 266(1) of Constitution of India. Similarly, all loans raised by government by issue of public notification, treasury bills, internal debt, and loans obtained from government from foreign government and international institutions external debt are credited into this fund. All expenditure of the government is incurred from this fund and no amount can be withdrawn from the fund without the authorization from the parliament, in effect that of Lok Sabha. Contingency Fund of India. Article 267. The Contingency Fund of India records the transactions connected with contingency fund set up by Government of India under Article 267 of the Constitution of India. This fund acts more or less like an impressed account of Government of India and is held on behalf of President by the Secretary to the Government of India, Ministry of Finance, Department of Economic Affairs. Public Account. Article 266(2). In the public account constituted under Article 266(2) of Constitution, the transactions related to debt other than those included in the consolidated funds of India. The transaction under debt, depositions and advance in this part are those in respect of which government incurs a liability to repay the money received or has a claim to recover the amounts paid. The receipts under public account do not constitute normal receipts of the government. Parliamentary authorization for payments from the public account is therefore not required. Center-state relations. Article 245 to 263. It deals with the relations between union and states. The center and state are an essential feature of the federalism. Legislative relations. Article 249. Power of Parliament to legislative in national interest. Article 250. During a proclamation of emergency, Parliament shall have power to make laws for whole or any part of the territory. Article 253. Parliament has power to legislate for giving effect to treaties and international agreements. Administrative relation. Article 260. Jurisdiction of the Union in relation to Union territories outside India. Article 263. Provisions with respect to interstate council. Financial relation. Article 268. Describes the duties which are levied by Union but collected by state. Article 269 describes the taxes which are levied and collected by Union but assigned to the state. Article 270 describes the taxes levied and distributed between Union and states. Article 280 Finance Commission. Commission on Center-State Relation. Setalwad Committee 1966. Rajamannar Committee 1969. Sarkaria Commission 1983. Punchi Commission 2007. National Party. It should secure not less than 6% of the total valid votes polled in its state during a general election. Besides, it has attained at least 4 members to Lok Sabha. State Party. It should secure not less than 6% of the total valid votes in that state of the general election. Besides, attaining at least 2 members to the legislative assembly of that state at that assembly elections. Emergency provisions. Types of emergency. The President is empowered to promulgate 3 kinds of emergencies on which are as follows. On the ground of threat to the security of India or of any part of the territory by war or an external aggression or an armed rebellion. Article 52. known as national emergency, on the ground of the failure of the constitution machinery in a state, Article 56, known as the President's Rule or State Emergency, on the ground of threat to financial stability or credit of India or any particular territory, Article 60, known as Financial Emergency. Effects of financial emergency. The executive authority of the center extends to directions as the president may deem necessary and adequate for the purpose. It may include a provision requiring the reduction of salaries and allowances of public servants, the reservation of all money bills for the consideration of the president. The president may issue directions for the reduction of salaries and allowance of union servants or the judge of Supreme Court and High Court. Thus, during financial emergency, the center acquires full controls over the states in financial matters. During the operation of financial emergency, the executive authority of the union extends to the giving of directions to any state to observe such canons of financial propriety as may be specified to the directions. The judiciary. We have an integrated judicial setup taken from 1953 Government of India Act in our country. The Constitution of India is the supreme legal document. Its Part 5 and Part 6 dealing with union and state governments respectively. Indian Constitution has established an integrated judicial system with the Supreme Court as at the top. Judiciary is independent of other two organs of the state, that is executive and legislature. Judiciary is a part of the democratic structure of the country. It is therefore democratic traditions and to the people of the country. Supreme Court of India is the highest court of justice in India, having one Chief Justice and not more than 30 other judges after amendment earlier 25. Total of 31 judges including Chief Justice of India. The judges hold the office up to the age of 65 years. Qualification as citizen of India. Any person who has been a judge of High Court for 5 years or an eminent jurist or has been practicing advocate in High Court for 10 years. Functions. It has important power of judicial review. It hears certain appeals of civil and criminal cases from High Court. It hears disputes between the union government and the states and between states. It can issue writs for the enforcement of any fundamental rights conferred by the Constitution. It has advisory jurisdiction and it also functions as a court of record. Removal of a judge. Judge of Supreme Court can only be removed from his office by an order of the President after an address by each House of the Parliament supported by a majority of the total membership of the House and by a majority of not less than two-thirds of the members present and voting on the ground of proved misbehavior and incapacity. The Constitution of the India has ensured that they can be removed by Parliament by complex procedure. After retirement, they cannot practice in any Indian court. Salary. Salary is given from consolidated fund which is not deducted except during financial emergency. Chief Justice's salary is 1 lakh rupees. Independence of judges. Decision and action of judges cannot be criticized. Any type of conduct of judges cannot be discussed in Parliament except in the case of removal. Chief Justice of India is appointed on seniority basis. Jurisdiction. The functions and the responsibilities of Supreme Court are defined by the Constitution. The jurisdiction of Supreme Court may be categorized as original jurisdiction. Disputes between the Government of India and one or more states. Dispute between the Government of India and one or more state on one side and one or more state on the other side. Disputes between two or more states. Example, Kaveri water dispute between Karnataka, Tamil Nadu and Puducherry. Public interest litigation. SP Gupta versus Union of India case 1982. Supreme Court held that any member of the public can approach the court for violation of fundamental rights of others who may not have sufficient resources to reach the courts. Even through a postcard, P.N. Bhagwati and V.R. Krishna Iyer were the prominent justices who have laid down the conditions for such appeals, popularly called public interest litigations, but PILs must work for public interest alone. Writ jurisdiction for the enforcement of fundamental rights. Habeas corpus. It implies that A person imprisoned or detained by the law can inquire from the court of law under the authority he has been imprisoned or detained. Mandamus literally means a command issued by the court commanding a person or a public authority to do or forbade to do something in the nature of public duty. Quo warranto, an order issued by the court to prevent a person from holding office to which he is not entitled and to oust him from that office. Certiorari, it is a writ which orders the removal of a suit from an inferior court to superior court or to squash the order of lower court. Prohibition by a higher court to stop proceedings in a lower court on the ground of overstepping of jurisdiction or isolation of the rules of natural justice. Advisory jurisdiction, Article 143. As the highest court in the country, the Supreme Court can be consulted by the President on certain issues. If the President feels that an important legal question or fact of public interest has come to him, he can ask the Supreme Court for its advice. The Supreme Court in such cases would consider it and give its opinion to the President. But such an opinion is not binding on the President. Appellate jurisdiction. Three types of appeals can be made to the Supreme Court, which are as follows. There can be an appeal against any decision or order of a High Court if the High Court gives a certificate that it involves some question of interpretation of Constitution. There can be an appeal against civil cases decided by a High Court if the High Court gives a certificate that the case involves a substantial question of law. In respect of criminal cases, too, there can be an appeal to the Supreme Court if a High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or if by withdrawing a case from the lower court to itself it has sentenced a person to death, one can go for an appeal to Supreme Court. Revisory jurisdiction, Article 137. The Supreme Court can review any judgment given by itself. The Supreme Court is also given the power under the Constitution to transfer a case that is being decided in any court and bring it to itself. If it feels that an important question of law is involved, Parliament can confer on the Supreme Court more powers by passing a law. Election jurisdiction. The Supreme Court has obligation to decide on the disputes regarding the election of the President and Vice President. Court of Record, Article 129. All the decisions and proceedings of the Supreme Court are kept as records and are quoted as precedents in the court. The court can punish for its own contempt if anyone does not abide by its decision. So the Supreme Court is called Court of Record. State government. It deals with the government at a state level, duties and functions of Chief Minister and his ministers, Governor, High Court Advocate and General of the State. High Court Advocate General of the State. The State Executive. The Governor and the Council of Ministers headed by the Chief Minister constitute the State Executive. Governor, appointed by the President on the advice of Council of Ministers headed by the Prime Minister. Same person can be appointed governor for more than one state. Qualification. Under Article 158, the Constitution lays down the following conditions for the governor office. He must be citizen of India. He should be more than 35 years of age. He should not be a member of either House of Parliament and the state legislature. He must not hold any government office of profit. Tenure. The Constitution prescribes a 5-year term for the office of a governor, but it's subject to the pleasure of the President. Power. Executive powers. Appoints the Council of Ministers on the advice of Chief Minister. Appoints the Advocate General, the Chairman and the members of State Public Service Commission. Acts as the representative of the President in the states. Legislative powers. He summons and prorogues the session of the state legislative. He can dissolve the state assembly before the expiry of its full term. He addresses the first session of the legislature after every election and first session every year. He can issue ordinances, appoints one-sixth of the members of Legislative Council on the advice of Chief Minister, nominates one member from Anglo-Indian community if not proper representative, gives assent to the bills to make it a law. The governor has three alternatives which are as follows. He can give his assent to the bill, he can return it other than a money bill for reconsideration, suggestions, alterations, but such bills when passed again have to be given assent. He may reserve the bill for the assent of the president. Financial powers ensures that the budget is laid in the legislative assembly. Money bills can be introduced on his recommendation only. Judicial powers. He is consulted by the President of India for the appointment of judges in the High Court, appoints judges of courts below the High Court, can grant pardon, reprieve, or remission of punishment for offence against the state laws. Emergency powers. The governor exercises important power during the emergency, which is also known as President Rule Article 356. Other powers: receives and tables the report by State Auditor General, acts as Chancellor of State Universities and appoints Vice Chancellor. Chief Minister. Article 164(1). Appointed by government, generally the majority party leader is appointed. A chief minister is elected head or government of the state and is vested with most of the executive power. He enjoys the support of legislators of the political party or coalition commanding an assembly majority. The governor is the normal executive authority, de jure executive, and the chief minister is the real executive authority, de facto executive. There are no educational or no qualification about his appointment. Under the constitution, all that is needed is that such person is a citizen of India and possesses such qualification as are required for becoming a member of the legislative assembly. Such a person could be a member of either house of the legislature or even an outside also, though in case he is not a member of state legislative, can be appointed CM, but he has to get himself elected within 6 months, otherwise would have to be removed. The governor may first appoint the chief minister, then ask him to prove his majority in the legislative assembly within a reasonable period. If the chief minister resigns, entire council of ministers resigns. The state legislature. Every state has a legislature. Some of the state legislatures have two houses: Legislative Assembly, Vidhan Sabha, in the lower house, and the Legislative Council, Vidhan Parishad, the upper house. States having bicameral legislatures are Uttar Pradesh, Bihar, Jammu Kashmir, Maharashtra, Karnataka, and Andhra Pradesh. State legislative councils can be created and abolished by the parliament on the recommendation of the legislative assembly. Legislative Council. It is known as the upper house. It cannot be dissolved. The maximum strength of the council is fixed at one third of the total strength of the assembly, and minimum strength is 40. Legislative council are elected in accordance with the system of proportional representation by means of single transferable vote. The council is constituted as provided in clause 3 of article 171. Strength and election. It cannot be larger than one third of the legislative assembly of the state. One third are elected by the local government bodies like Zilla Parishad, municipalities. Another one third are elected by members of Legislative Assembly of the state. 1/12 are elected by the constituency of graduates, and other 1/12 are by teachers of secondary schools, colleges, and universities. 1/6 of the total members are nominated by governor from the persons of special knowledge or practical experience of literature, science, art, cooperative movement, and tenure social service. 6-year tenure with one third members retiring every 2 years. Qualifications: citizen of India, not below 30 years, chairman and vice chairman elected from amongst its members. Legislative Assembly. Its term is 5 years. It can be dissolved before completion of its term. Its term can be extended by 1 year during national emergency. The constitution says that the governor may appoint one member from the Anglo-Indian community if it is not adequately represented in the House. The rest of the members are elected directly by the people from the territorial constituency. Article 171 holds that the Legislative Assembly of each state shall consist of not more than 500 and not less than 60 members chosen by direct election from territorial constituencies in the state. Strength. The strength of legislative assemblies cannot be more than 500 and not less than 60. However, in case of Arunachal Pradesh, Sikkim, Goa, the minimum number is fixed at 30. In case of Mizoram and Nagaland, it is 40 and 46 respectively. Qualifications: a citizen of India, age not less than 25 years. Speaker and Deputy Speaker chosen from among its members. Must possess other qualifications prescribed by Parliament and under the Representation of People's Act 1951. High Courts. The Constitution provides High Court for every state, but even two or more states can have a common High Court if provided by the Parliament. Presently, there are 24 High Courts in India, 21 plus 3 state High Courts. The states of Meghalaya, Manipur, Tripura have created the new High Courts. The High Courts consist of a Chief Justice and some other judges appointed by the President of India. There is no upper limit of number of judges. Qualifications: he must be a citizen of India, must have held a judicial office for at least 10 years, or be a distinguished jurist in the opinion of President. He should have at least 10 years he should have for at least 10 years been an advocate in the High Court or of two or more such courts in succession. For the appointment of Chief Justice of a High Court, the President consults the Chief Justice of India and Governor of the concerned state. Other judges are also appointed according to the same procedure. The Constitution Bench of Supreme Court held that the opinion of Chief Justice, Supreme Court and High Court will be given the priority in both the appointment as well as transfer of senior judges. A judge of High Court holds his office till he attains the age of 62 years. Their term can be shortened if he gives resignation and can be cut short if removed by the President. Judges of one High Court can be transferred to another High Court. They can be removed from the same procedure as followed in the case of judge by the Supreme Court of the Supreme Court. Parliament passes the resolution by a two-third majority of its members present and voting. The High Court is the High Court is the highest court of the appeal in both civil and criminal cases in the states. The High Courts of Delhi, Kolkata, Chennai, and Mumbai have both appellate and original jurisdiction. The original jurisdiction of the High Court of other states is limited only to the matters mentioned in the Constitution. In civil cases, an appeal can go to the High Court if the amount involved in the case exceeds 20,000 rupees. Appeals in criminal cases from the lower courts. Conduct of judges of high courts cannot be discussed in Parliament except on a motion for the removal of the judge. The High Court has a power to issue writs both for the enforcement of a fundamental right and for other purposes. Article 226. But Supreme Court can issue writs only uh, but the Supreme Court can issue writs only for the violation of fundamental rights. So the writ jurisdiction of High Court is wider than that of Supreme Court. The High Court has a power of superintendence over all courts or tribunals except military tribunals within their respective jurisdiction. The High Court has the power to transfer cases either to themselves or from one lower court to another lower court. High Court supervises the working of all the subordinate courts and frames rules and regulations for the transaction and business, and it examines records of its subordinate courts also. Subordinate courts. Article 233 to 237 in a part 6 of Constitution makes the provision to regulate the organization of subordinate courts and to ensure their independence from executive. The appointment, posting and promotion of district judge in a state are made by governor of the state in a consultation with the High Court, Gram Nyayalayas. This act came into force from 2nd of 2009 to provide for the establishment of Nyayalay at the grassroots level for the purpose of providing access to justice at the doorsteps of the citizens. The central government will meet the non-securing expenditure of courts. More than 5,000 Gram Nyayalayas are expected to be set up. Lok Adalat is an alternative dispute settlement mechanism which settles disputes through conciliation and mediation. All legal disputes pending in civil, criminal, revenue courts and tribunals can be taken to Lok Adalat. Constitutional bodies of India. Attorney General. The Attorney General of India is appointed by the President of India under Article 76 of the Constitution. A person qualified to be a judge of Supreme Court is appointed to such a post. He is the highest legal advisor to the Union government and is consulted in all important cases. He also appears in the Supreme Court on behalf of Government of India to conduct cases. He has the right of audience in all the courts and can take part in the proceedings of either houses of parliament, but he is not entitled to vote. He holds office during the pleasure of the President, Comptroller and Auditor General. He is appointed by the President for control and audit of public accounts. His main functions are as follows: to keep a vigilant watch on the finance and of on the finance of union and the states, to submit periodic reports to the President and governors of the state for consideration of Parliament and state legislature, to see that the amount voted by the legislature is spent under appropriate heads and they are not exceeded. Finance Commission, Article 280, composition. Under Article 280 of the Constitution, provision has been made for the constitution of a Finance Commission within 2 years of the commencement of the Constitution and thereafter on expiry of fifth year. It consists of chairman of four other members appointed by the President. Functions. It is the duty of Finance Commission to make recommendations to the President as to the distribution between Union and States of net proceeds of the taxes which are divisible between the Union and the States. The principle which should govern the grants in aid of the revenue to the states of out of the consolidated funds of India. Measure of augment consolidated fund of state. Any other matter referred to the commission by the president in the interest of sound finance. Union Public Service Commission. It is a constitutional body. The chairman and other members of UPSC are appointed by the president. Every member holds the office for a term of 6 years until he attains or until he attains an age of 65 years, whichever is earlier. He can submit his resignation at any time to the president. He may be removed from his office by the president on the grounds of misbehavior or incapacity. State Public Service Commission, SPSC, consists of a chairman and other members appointed by the governor of the state. The chairman and the member of commission holds the office for a term of 6 years or until they attain the age of 62 years. They can relinquish their office at any time by addressing their resignation to the governor. Although the chairman and members of SPSC are appointed by the governor, they can be removed only by the president. Election Commission, Article 329. It consists of a Chief Election Commissioner (CEC) and two election commissioners. The CEC and other election commissions are appointed by the President. Tenure for CEC and EC 6 years or 65 years of age, whichever is earlier. First Chief Election Commissioner of India is Sukumar Sen. Removal of Chief Election Commissioner can be done in the same manner as the Judge of Supreme Court of India. Other election commissioners can be removed by President on the recommendation of Chief Election Commissioner. Union Territories. Article 239 to 241, it deals with Union Territories. Union Territories are administered by the President. Administrators of Andaman and Nicobar Islands, Delhi, Puducherry are designated as Lieutenant Governors. Chandigarh administered by Chief Commissioner. Jammu and Kashmir, special status abrogated. Panchayats. The idea of Panchayati Raj forms a basic test of Gandhian philosophy that concision village councils as the units of left governance. Duration. It has 5 years of duration from the day of appointment for its first meeting. Election. Before the expiry of its duration. Before the expiry of a period of 6 months from the date of its dissolution, provided that where the remainder of the period for which the dissolved panchayat would have continued is less than 6 months, it shall not be necessary to hold any election for such periods. Reservation in panchayat. Seats shall be compulsorily reserved for scheduled castes and scheduled tribes. Seats to be reserved for backward classes is left at the direct discretion of the state government. One third of the seats are reserved for women. State Finance Commission. There is a provision of State Finance Commission to review the financial position of panchayats and recommended grant in aid. It shall make the following recommendations to the government. Governor. The distribution between the states and panchayats of the net proceeds of taxes, tolls, and fees be viable by the states. The determination of the taxes, duties, tolls, and fees which may be assigned to the panchayats. The principle that will determine grant in aid to the panchayats. Municipalities. Article 243. The first municipal corporation was established in Madras Presidency in 1687. Duration 5 years. Election must be held before the expiry of its duration or before the expiry of a period of 6 months from the date of its dissolution. Amendments to the Constitution. Article 68. It deals with the constitutional amendments. An amendment to the Constitution can be initiated in either House of the Parliament, and there is no provision of joint session here. President has to, under all conditions, provide his consent to such a bill. He cannot withhold his consent, or nor can he return it.